Okay, so it's like we can start now.
Okay. A very good evening to one and all present here. I take this privilege again to warmly welcome our esteemed guests, faculty members, and fellow students to the second day of this online mediation workshop being organized by Uslls. Before formally commencing this event, I request all the attendees to kindly switch off their videos and mute themselves in order to avoid any unwanted disruptions. Without further ado, I would want to pass it over to Mr. Aman Hingarani, sir, whose yesterday's insight on the skills required in mediation has been a rich knowledge for all of us. He'll be speaking on online mediation and the mediation skills required in ease of doing business today. Over to you, sir.
Well, thank you very much. Now, yesterday we had discussed basically about how to do mediation, what are the skills that you as a mediator should possess, how to do pre-mediation summary or briefing, analyze the dispute, get into the mediation session with opening statement, run the session between joint and private sessions, taking the parties through different stages of mediation. But the idea being that it is the parties who themselves open up communication channels and negotiate to come to a settlement by themselves. Now, that is the traditional structure of a mediation. But even before the pandemic, there was a move towards online dispute resolution, ODR, and this has received further urgency in view of the pandemic. We don't really have a choice. We are forced to move virtually onto online platforms. Now it's easy to see where the difficulties are, because if the mediators and the parties and the lawyers have to mediate in a particular session, they would have to sit socially distanced in a room. They would have to wear their masks, face shields. There would be glass partitions. Everything that takes away from the informal process that mediation is. Apart from, of course, the fact that everybody has to be tested, they've got a COVID negative test. On the other hand, having an online mediation would have its own advantages. And that is something which we have figured out over the last almost 2 years, about how convenient mediation can become, because mediation session can be scheduled in order. You don't have to wait, and particularly in reference to court next mediations, I don't really need to wait for a court hearing time between 10 to 5, the court working hours. I can schedule a conference at odd hours. It's easier to ensure attendance of all the people because nobody really needs to travel. Particularly in the Supreme Court, where you have transfer petitions seeking transfer of case from state A to state B. Parties are from all over the country. And should you have a mediation in the Supreme Court Mediation Center, the parties would have to commute from different parts of the countries. If you do online mediation, that this whole commuting and travel gets obviated. You simply get the parties to log in from a place of their comfort. Also, in certain kind of mediations, it is particularly where emotions run high, there's extreme hostility or trauma. Parties feel safer in a virtual setting, particularly when you can switch off the video and not see the other place. So the virtual medium acts as a buffer, which can help in preventing the environment from from vitiating the environment or it becoming a hostile environment. So you can actually do mediation faster, with greater agility, with less cost. And so these are the obvious advantages. But having said that, there are also certain other requirements. Everyone, including the mediator, the lawyer, the participants, must understand how to use the technology. They must be at ease in using the technology. The platform must be functional. Very importantly, it must be confidential. It has to have options of having private rooms. If you want to have a caucus or a private session, you need to have a private room. The platform must have good video and audio quality regardless of the number of people who are logged in. We have seen that if you have multiple parties, multiple participants, then there's a lot of disturbance. The video quality also is not particularly good. More so if you have lengthy sessions, and mediation can be lengthy. You can have sessions going into hours. So you must have a platform which can give this facility, also protect the data. We've talked about confidentiality, but what if the data gets leaked from the platform itself? It takes away from the confidentiality. So you must have a secure platform. You must have somebody at hand who can deal with unexpected glitches. Maybe a software user-friendly guide in jargon-free language so that parties will also know how to use the technology. And then, of course, the parties must have devices that support that platform, complete with video and audio facilities, a good, secure internet connection. If the parties are joining into mediation from the comfort of the house, then the parties must ensure that there is adequate lighting, there's a suitable backdrop. It will take away from the mediation process if you have, for instance, children playing around in the background or people shouting across the room. The parties also have to commit not to interrupt the session by taking external phone calls. They have to maintain confidentiality by not sharing the meeting ID. They should not be recording the sessions. They should not be taking photos or images, because each of this would be a violation of the confidentiality provision. Participants also, the mediator of course has to take care that the participants might feel stressful to focus on the screen for several hours at a stretch. And parties may actually may lack confidence if they are not very tech driven. Particularly the older generation, they will feel intimidated by the technology. So there are many pros and cons and additional requirements if we're talking about online mediation. But the structure of the mediation, even when we do it online, is similar to that as what we do in the physical setting. So there will be an opening statement, there will be private session, joint sessions, there would be the entire stages of mediation will have to be gone through, and so on and so forth. But as you would have noticed, and as I pointed out yesterday, the mediator, in addition to the mediation skills, would also require technological skills. The mediator should be able to mute and unmute the parties, should be able to switch on the videos or switch off the video. The mediator, if he's getting into a private room, has to announce that I'm coming to a private room. Because in a physical setting, what we normally do is we request a party to step out. Here, unless the parties are put in a waiting room by the moderator, it's a different situation. But where the mediator has to go from room to room, a mediator cannot simply enter a private room unannounced. The mediator must tell the party or take the permission of the party to enter the room. And once in the room, the mediator must ensure that it's only the people who are part of the process should be in that room. Then the other safeguards a mediator must take. In a physical setting, the parties have the luxury of talking to their counsel by simply whispering in the ear or bending forward and talking to them in a low tone, or just stepping out of the room and having a quick conference with the counsel. You can't do that in an online mediation if the party and the counsel are at different locations. So we have had situations where the party is texting or putting a question to the counsel in the chat box without realizing that that chat is visible to everybody, particularly the host. And so the mediator should forewarn the parties that should you want a confidential discussion with your counsel, or vice versa, the counsel wants to talk to the party, please do it through WhatsApp, email, or on phone. because the chat log of the mediation platform will be visible. So these are the kind of issues which will arise, which are technology driven. Then there are other issues. For example, in a private session, in a physical setting, there's a private session going on with party A. Party B can take a walk and go and have a cup of tea. Can can keep himself or herself busy by being in the same place by talking to other people. But in online mediation, the party is looking at the screen, waiting for the private session with party A to get over so that the mediator could speak to that party, to the other party. So it's always good for the mediator to keep updating the party who's waiting how long that private session will take. Because otherwise the party would become impatient, they lose interest in the process. Given the limitations of online mediation, it is advisable to set an agenda. When will we break for tea? When will we have lunch? So agree in advance on the breaks that have to be taken. Also, the mediator has to appreciate that parties may not be used to speaking in a camera. When looking at a screen, we actually look at the display, but the eye contact is normally you get the eye contact when you look into the camera, not on the display. So it may be unnerving to the participants to speak and listen to a camera. So the mediator may have to actually have shorter sessions. Certain kind of mediations you can't do virtually, particularly where you need to do restorative justice sessions, where you need to deal with trauma, where that human touch is important, where you need to be there to let people vent emotions. Nobody can vent on a screen. And so certain kind of mediations are better suited in the physical setting. But having said that, both online mediation and physical mediation supplement each other. And so we can have a hybrid model. Some you can have physical, some you can have online, depending on the nature of the case. So cases where there are emotions involved, like family disputes, partition cases, partition disputes, matrimonial cases, you could perhaps focus more on physical mediation, though from experience I can share that there's a lot of emotional component even in commercial cases. It may be a tussle between management of companies between a father and son, but it can actually boil down to the father being run down by the son saying you're outdated or I don't like the way you run the company. So the trigger for the dispute could be emotional as opposed to a financial deal. So almost all cases do have an emotional component, but certain kind of cases have a more of an emotional component, like matrimonial cases or family disputes. And they should anyways be done through the physical setting, not online mediation. Certain kind of cases like commercial matters, IPR matters, these kind of matters can perhaps be, one could experiment with online mediation when you come to these kind of cases. So this is broadly about the transition from a physical setting onto an online setting. But not only is it a change the minutes we start using technology, more so in context of business disputes, because if you also may recall, there was an ordinance of May 3rd, 2018, which amended the Commercial Courts Act of 2015, providing for mandatory institutional mediation. So should somebody want to file a suit which is commercial in nature and does not require any urgent relief, then the court cannot entertain the suit unless the parties have first tried to have the disputes resolved through mediation. So it's mandatory institutional mediation prior to the court entertaining a particular suit. So when we're looking at business disputes and we're looking at the ease of doing business, not only is it important to know about the transition for the physical to the online medium, but also how technology can help open new areas for mediators to resolve certain kind of disputes that is specific to technology intersecting with the digital market, with the commercial market. We have artificial intelligence now, we have blockchain technology, we have smart contracts, and this has led to the commercial world intersecting with the law. And then new kind of disputes that have arisen, for which in my personal opinion, mediation is a better mechanism to resolve those disputes than litigation or arbitration. And let us understand why. Before we get into how mediation can be effectively used for these disputes, let us also first understand what we mean by artificial intelligence, what we mean by blockchain technology, what we mean by smart contracts. What is the nature of disputes that can arise? And so as to make mediation a better option than litigation and arbitration. Artificial intelligence has been there for a long time. Initially, they were used to solve simple e-commerce disputes where the monetary amounts are small, so a small amount of money is involved, and the person who's supposed to make the payment doesn't really want to contest it. It's not really worth contesting the small amount which is claimed by the other side. And so, should a consumer complain that this particular dress is defective, there's some goods are defective, the company's website will simply use an algorithm rather than a human intervention. There's a formula they'll use to generate a cheap and fast online decision. You won't really be talking to a person. You simply feed in your complaint, and the website will work out through a formula, predetermined formula, that okay, this amount should be refunded. So you use artificial intelligence to resolve the dispute. Blockchain or distributed ledger technology is basically a digital ledger database which gets shared by a community of participating users. So if you want to execute a transaction or you want to put in some information, you simply code a request in the system as a digital block. So they're digital blocks, they all get chained together by all the users to the existing digital blocks. The result would be a decentralized chain of digital blocks that represents identical ledger database for all users. So every transaction can be tracked, is recorded. It's possible for the user to verify the content, data, the chronology of the data which has been coded in. And the minute you code in something, you get an output, which is a unique code. So that hashtag or hash function is a protection against tampering of that data. You can't alter that data. So basically, if you think about it, you can have computers all over the world. Because of using this blockchain technology, all the computers will have the same database, in form of a ledger, where they can track and record transactions. So that is a blockchain technology. And smart contracts these days use blockchain technologies to execute commercial transactions. Now, basically, smart contracts, a textbook definition of a smart contract is that it's a set of promises in a digital form that enable parties to engage in self-executing transactions along the terms which are already been coded into the system. So if you see a textbook example, if you open any book and talk about what was smart contract, you'll say, well, and I'm sure all of us have experienced this at some time. You go and you want to buy a drink from a self-vending machine. There's a slot, you put in the money there, and a drink comes out. That's an early example of a smart contract. The transaction cannot be stopped. The minute you put the money in, the drink will come out. The terms of the smart contract is embedded in the software and the hardware of the machine itself. So this was an early application of smart contracts. Now we have more sophisticated smart contracts. Another textbook example of a smart contract which is used in these times could be a flood insurance policy. The insurance company would automatically pay the claim on receiving a feed from the Met Office that a certain amount, stipulated amount of rainfall has been recorded in a particular area. So the minute that stipulated amount of rainfall has fallen, a feed goes from the Met Office to the insurance. It will presuppose there is flooding and the claim will be released. So the idea is to trigger off the contract irrevocably, certain conditions being satisfied. So smart contracts are basically swift, irreversible, self-executing, unambiguous, and secure contracts. And since they're self-executing, they reduce the operational costs substantially. If this is a smart contract, it's again easy to visualize the kind of issues that can arise. There could be a coding error, so you get an unexpected performance issue. The codes could be defective. So you put in the example I'd given of a vending machine. You got a drink, but the drink is past expiry date. You might have an inaccurate data feed, which causes unjust enrichment to a particular party. Now, smart contracts are irrevocable, irreversible. But suppose somebody wants to terminate a contract saying, well, I entered into this contract based on fraud or misrepresentation or mistake or under coercion. I want to terminate it. You can't terminate a smart contract. Then there could be hacking by exploiting bugs. What about force majeure? How does that figure out? If we see these are the kind of issues that arise, and there are many more, this is not being exhaustive, there are many more kind of issues. How does one use the adversarial system, arbitration, litigation to address these kind of disputes? Because most jurisdictions around the world, they don't even recognize a smart contract. And there's several reasons for that. Most of these contracts are executed by not knowing who the person who initiated the smart contract. There's an uncertainty as who are the contracting parties. Most common law jurisdictions, including India, even in Section 10, there's a requirement as to the legal capacity of a person to enter into a contract. We must know who are the parties to a contract. We must know who to sue. Similarly, because smart contracts operate on the distributed ledger base, which is all over the world and through different computers. Since the computers are located in different parts of the world, how would you know which is the competent court, which is the competent jurisdiction of a court, which is the applicable governing law in case of a dispute? And then you're going to have litigation, collateral litigation surrounding these issues. Is this the right court or is this the right court? Is this the right law or is this the right law? So that will lead to even more litigation. Then there could be issues of evidence. How do you determine who was liable for defective coding or for message being corrupted or for bugs in the operating system? Then there could be issues of disclosure, because many of these software, there's a proprietary rights in the software and hardware. By disclosing them in the public domain, there could be serious commercial ramifications. A party may not want to disclose this in the public domain. Then again, as I pointed out, how do you stop a contract? In case a particular relief is incapable of being enforced, the court can terminate the contract and give a relief that this contract is terminated. But you can't seek that kind of relief as far as smart contract is concerned. As far as India is concerned, I pointed out we have the requirements of Section 10 as to what is a valid contract. We have provisions in the Information Technology Act. You have Section 10A, which contemplates electronic contracts. You have detailed provisions which talks about electronic governance, including legal recognition and security of electronic signatures, digital signatures. Though, of course, they must be issued by a government designated certifying authority. In our Evidence Act, we have provisions, Section 85A to 85C, which talks about certain presumptions as to electronic records, electronic signatures, electronic signature certificates, and so on and so forth. You have Section 65B of the Evidence Act, which talks about admissibility of electronic evidence. We have Section 88 again, 88A of the Evidence Act, which raises about certain presumptions. So a smart contract which satisfies Section 10 would be a legally valid contract in India. But the difficulty would arise that should there be a dispute on the admissibility of this contract, because it is the primary reason for this is that for a smart contract to be admissible in India in evidence, the electronic or digital signature must be that which is certified under the Information Technology Act. The current technology provides for a signature generated by the system, by the blockchain. There's a hashtag which comes out, a hash key if you want to call it. That is a signature. That signature is not recognized by our courts to be the valid electronic signature. It is only a signature which is recognized under the Information Technology Act that permits that smart contract to be admissible in evidence as far as India is concerned. And then also there's no clarity about cryptocurrency, which is a form of virtual currency, is that lawful consideration for Section 10 of the Contract Act. So we have a lot of issues which are there, not only in India, but across the world, as to whether the adversarial system, whether it's litigation or whether it is arbitration, whether that is a better mechanism or a suitable mechanism to address these kind of issues. It is here that mediation comes in, complete with the confidentiality clause. Since we are not getting into the legal rights necessarily in a mediation, we sidestep most of these issues through the mediation process. And more importantly, as you probably are all aware, that these days all contracts, particularly all international contracts, they have a multi-tier system. Should there be a dispute, we'll first try to negotiate. If negotiations fail, we'll try to mediate. If mediation fails, then we go to arbitration and so on and so forth. So there are several levels of trying to resolve the disputes. There's nothing to prohibit the parties providing for an automated mediation and enforcement of settlement agreement in smart contracts. Suppose a party says in the smart contract that should there be a dispute, we are giving our consent to go for mediation. The smart contract provides for the mechanism of nominating a mediator or opting for institutional mediation. The smart contract can provide for giving predetermined access to the mediator to the smart contract in order to enable the mediator to code or insert the settlement agreement in the blockchain, so that the minute the mediator puts in that settlement agreement, it will automatically lead to the transfer of assets from one party to the other on the blockchain in terms of the settlement agreement. So basically, you're talking about automated mediation. You're talking about enforcement of settlement agreement in the smart contract. That itself would be a very effective way of resolving commercial disputes. And there is no prohibition. It is conceptually and technologically possible to do it. Of course, should the assets on the blockchain not be sufficient to satisfy the settlement agreement, and you're looking for assets outside the the blockchain and into physical assets in a particular state, then that state must be capable of recognizing a smart contract, enforcing a smart contract. That's a separate issue. Or should the blockchain itself have sufficient assets which can be transferred from party A to party B in terms of a settlement agreement, then the mediation settlement agreement itself can be self-executing. So just by this, I'm sure a lot of this would be alien to some of you. But the point basically is that the minute we start using technology, the minute we start using, we go beyond the physical setting of mediation, and mediators become technologically adept in doing mediation, then we need not be confined only to focus between transitioning between a physical setting and a virtual setting. There are substantive areas where mediation can be used to resolve certain kind of disputes more effectively than arbitration or litigation. Of course, for this, the mediator must be trained. As I've said, we're training about, where we talk about training mediators in mediation skills, whether communication, negotiation, and facilitative skills. A mediator should also be trained in the technological skills. I'm also aware that most of the law schools, at least in India, do not impart these kind of trainings. And so I do recognize that some of the students might feel inadequate, that here a whole range of performance skills we're talking about, and where do we get them from? How do we acquire them? Because these are skills that can be taught, that can be imparted in a scientific structured manner. For that, in your university, in IP University, of course, you've had programs in the past, but there are also in other universities where there are programs where these performance skills are taught by learning by doing sessions. Should any one of you want to know more about that, you could always get in touch. But there are places where you as law students can join these courses to do in a class simulation exercises, to do learning by doing sessions. Most universities do run these kind of sessions where one of you would be a mediator, two of you would be the parties. You would run a mediation session on hypothetical cases for about an hour. Then you'll have a group discussion. The parties will be giving feedback to the mediator, or you could be having a group discussion on the performance of the mediator or of the parties. This is being done. But in my view, again, this is not adequate because there's no individualized, structured feedback on every performance by a faculty as to where that student could have done better. We do have more modern teaching methods by which a structured feedback can be given, for instance, on opening statement. One area of concern, giving a feedback as to what the student had done, giving a reason why it's area of concern, giving a remedy, the faculty themselves doing demonstrations here and there, getting the student to do a replay. These are a structured review which we use for advocacy training, but can also equally be applied for mediation skills training, followed by a video review where the performance of the student has been video recorded and a review is given on the stylist issues of, say, body language. Was a mediator more sitting in a manner which was more directed towards one side, which took away from his neutrality? Was a mediator dominating the conversation? Was the mediator not having proper eye contact with both parties? Was the mediator using words which were not or which could not diffuse the hostility? Did the mediator use neutral reframing at the right time? A lot of these issues can be picked up through video review feedback on each individualized performance, not a group discussion, not a general feedback by the participants or the faculty. So there's far more intensive teaching methods which are there, which are available in courses. And I would strongly encourage whoever would want to do mediation. Mediation is not everybody's cup of tea. Not everybody has a temperament to do mediation. But should you feel this could be a good vocation, a good profession, you're interested or you find it far more satisfying to be able to get parties to settle than to litigate, then you do need to equip yourself with all the skills you've been talking about yesterday and today. So what I intend doing now, since it is almost 4:40, and I did realize that yesterday's session, there were more questions. A lot of you had questions, but we have a short of time. What I would do is I'll stop here on this issue of online mediation and the ease of doing business. And I would invite questions, uh, not necessarily confined to today's discussion, but also what we talked about yesterday. So today then we can spend more time in having more of an interactive session on the entire range of the points that have been discussed yesterday and today. So would there be questions? I can see there are some questions, maybe. There is a question. Are there any questions?
Sir, there's a single question I can see,
Yes.
which states that how is mediation and arbitration different? If you
Okay.
want to state.
So would somebody like to answer that? Let's make this more interactive. How are mediation and arbitration different?
One difference could be that arbitration is binding, but the process of mediation is not binding, just the settlement that arises from mediation is binding.
So the distinction which you're trying to make is that the arbitration is binding, both in terms of process and the decision. But as far as mediation is concerned, the process is not binding. It's only the settlement which is binding.
Yes, sir.
Is that the crux, or would somebody else like to have a go?
I
In mediation, in mediation, we are not to influence the parties. We are to let them settle dispute themselves. We are not to influence them. But in arbitration, we have some sort of authority over the two parties. So I think that's a difference between mediation and arbitration. In mediation, you are to let them do the thing, and you are not to stop them.
Okay, so one is which is the entity which makes the decision. In arbitration, the arbitrator perhaps will be deciding. In mediation, it's the parties who decide. So that is one distinction. And anybody else?
So additionally, mediation is voluntary process. Arbitration can be ordered by the court, or parties have to agree to the arbitration clause prior to that. So
So if there is an arbitration clause in a contract, and a contract is with the consent of the parties have consented to arbitration. And by the same token, we have had even judgments now for the proposition, though not entirely correct in my view, that a court can refer the parties to mediation under Section 89, even when the parties are not really interested in going for mediation, but where the court feels there is an element of settlement. So the initiation of mediation can be mandatory. Of course, the continuation of mediation would be voluntary. Parties can turn up before the mediator and say, we don't want to mediate. So that distinction as to whether it's mandatory or voluntary is again has different facets to it. But broadly, let us see. Let us talk about each of these mechanisms. Now, suppose there is a dispute between A and B. A goes to his lawyer, B go to his lawyer, and they present the case before third neutral party. If that third neutral party is a judge appointed by the state, then the process you have is litigation, is adjudication, where the judge will be applying a standard of law, the standards which are laid down in law, to the facts of the case and say which party should be given the relief. So one party wins the case, one party loses the case. So there's a decision that conflict, that dispute is decided one way or the other in favor of one party and the other. And of course, you have the hierarchy of appeals, first appeal, second appeal, and so on and so forth. Now, if instead of that third neutral party being a judge, you have a private party who's called an arbitrator who is deciding the dispute, then that process is arbitration. Here also it is adversarial. You would have the arbitrator applying the law on the facts of the case. It is slightly more flexible than that of litigation because an arbitrator is not strictly bound by the Evidence Act. The arbitrator can follow the procedures, can follow the procedure which is agreed to by the parties. You can have fast track arbitration, you can have pleadings only arbitration. So there are innovations within arbitration. But essentially, the process is adversarial. One party is trying to assert their right, the other party is trying to assert his or her right. And so, again, what comes out is an award, an arbitral award, which is an adjudication, which is a decision where one party wins, one party loses. So again, that conflict, like in litigation, gets decided in favor of one party. Because it's a decision by a third neutral party deciding the future of the conflict between A and B, who have no control over that. Both, whichever party loses, whether it's A or whether it's B, that party is going to be dissatisfied. You lead to deterioration of relationships. You lead to one conflict might be triggering of other conflicts. And then there's certain kind of reliefs that a court cannot give or an arbitrator cannot give. Most of the disputes are not have actually arisen because of a wrong tone of voice or because of somebody's ego being hurt or somebody feeling run down or somebody feeling they've been taken for a ride. Many times a simple apology is good enough. No court, no arbitrator can direct a party to apologize. They can give a judgment, they can decide their rights and liabilities, but you can't force a person to apologize. And so, for some of the cases, arbitration or litigation may not be appropriate. So, ADR, many people say, is not alternative dispute resolution. It is appropriate dispute resolution. Certain cases are better resolved through non-adversarial methods. Now, in non-adversarial methods, there can be many different kinds of mechanisms. One could be a negotiation directly between the parties, of course, by the parties themselves or through the lawyers or representatives. Another could be going to a third neutral party who is a mediator, who helps facilitates a settlement where the mediator does not focus on the legal rights of the parties, or the stands of the parties, but tries to understand why are they taking the stand? What is biting this person? Why are they behave? Why do they want this? And if the mediator can uncover common interest between the parties so that both those interests can be satisfied, then the mediator can help the parties come to a settlement where the parties agree. Mediator cannot impose a decision. Mediator can simply guide the parties towards that particular settlement agreement, assist in the negotiation so that the parties themselves come to a settlement which addresses the underlying interest of the parties. If both sides' underlying interests are satisfied, then that it may be a decision, but it's actually a settlement. It's a win-win situation. Both sides have won. There's no loser. And since there's no loser, relationships will improve. People will be able to move on in life. That's why we say mediation is a healing touch. And coupled with restorative justice practices, you might actually also bring in a closure to the emotional trauma associated with a particular conflict. So mediation is non-adversarial, where the effort of a mediator is to get parties to satisfy the underlying interests so that both of them feel that they've got something out of the process, because it is the parties' settlement, it is durable, the parties won't file appeals, you don't need to go up to the hierarchy from trial court to Supreme Court. And since it is finishes at that level, it is faster, cheaper, more effective. And should one party, as I pointed out yesterday, many times we say or do things which we don't intend to say or do. They may be hurtful. We don't even realize how hurtful they may be on the impact, the hurtful impact it has had on the other side. The minute the other side shares how hurt that person was, we ourselves might say, well, we didn't mean to hurt you. We are sorry. We express our regret. That was not the intention. That itself can finish off the dispute. A person can say sorry. A person can express regret. And the dispute is over. So you rebuild relationships. There's more satisfaction in society. So conceptually, it is completely different. You have to transition from an adversarial mindset to a consensual mindset, where instead of focusing on trying to see whose blame it is, you're focusing on how to repair the harm. Rather than seeing, let me paint the other side black, in a mediation, you try to say, whoever may have been at fault, what will it take to move on in future? So the aim, the purpose, the scope, the skill set is completely opposite. Are completely opposite in litigation and mediation, or in arbitration. So in litigation and arbitration, you're not bothered about the reason for the conflict, the socioeconomic context of the conflict. In mediation, you're concerned with the socioeconomic context, why a person is behaved in a particular way, and what we can do to make that person feel they've got the relief. And actually, it is this which is also the broader role of a lawyer. In my view, the proper role of a lawyer should be able to get the relief to the client without having to go to court. It's only where it's not possible to go to have the case resolved through ADR or through alternative mechanisms, then you go to court. Of course, there are certain kind of cases that cannot be sent to mediation. You can't have a case of constitutional law being referred to mediation. You can't have a murder case being referred to mediation. You can't have people accused of heinous offenses like dacoity, rape being sent for mediation. So you can't mediate where there's a terror, a person who's guilty of doing terrorism. So there's a certain category of cases, and the Supreme Court incidentally has listed those kind of cases in Afghan's case judgment, which are not that suitable for mediation. But generally speaking, the cases from which they're suitable for cases in which can be mediated, mediation is a skill set, it's a life skill, where you try to handle conflict in a completely different manner. You transform conflict in a win-win situation. So you must keep this conceptual differences between litigation, arbitration, mediation in mind, because your approach and your skills vary from all. For communicate, it's like a pyramid. At the base is communication skills. Superimposed on the communication skills are negotiation skills. Superimposed on the negotiation skills are facilitative skills and not technological skills. For the adversarial system, you would need to have your communication skills and client interviewing skills, of course. Based on that, you would have skills to know how to do a case analysis, to formulate case. You You would need to have skills how to do legal drafting. Superimposed on that, you'll need to have skills to be able to handle witnesses. And then you need to have skills how to present arguments. So the skills are completely different in adversarial and non-adversarial means of resolving conflict. Yeah, so now there is some more questions.
So there's one particular question, which is stating the future of online mediation, considering right now it was a necessity. What do you vouch for the same in future?
Well, like I pointed out, that we could, of course, go in for a hybrid system because certain kind of cases can effectively be dealt with virtually, particularly if parties are in different parts of the world, or or even different parts of the country. So it can be very effective for doing that. But the kind of issues, like I say, the kind of issues which I faced. Suppose there's a settlement agreement. I have a digital signature. I can, of course, sign using digital signature. Or do the parties sign? Some of them may not have a digital signature certified under the IT Act. So for signing the mediation settlement, they would have to meet physically, even though the settlement was arrived at through virtual mediation. So there are issues, no doubt, which are there between which come in when you do online mediation. And so I would, rather than saying which one is better, I would simply say certain kind of cases can be better resolved through online mediation, which can be then supplemented by physical meetings simply to sign the papers should they be no if the parties don't have digital signatures, though I'm told again in High Court, Delhi High Court, for instance, in one of my matters, I was told that the parties don't need to sign; they can simply send an email confirming the terms, because the matter would then go to court and the court would dispose it off. So an email is good enough. So we would need to innovate means of handling the kind of issues that have arisen because of online mediation. According to me, there's no reason why online mediation can't be here to stay forever. So, in fact, and for that matter, even when we argue our cases, certain kind of cases on miscellaneous days in the Supreme Court, or certain kind of cases which are before the registrar, can be done online, virtually, the way we're doing it right now, even when the pandemic goes away. Certain kind of cases where there are multiple parties or lengthy arguments or voluminous reports, they have to be done physically. So the way we're drawing distinctions in the kind of cases that can be done online and physically, similarly in mediation, we can draw those kind of distinctions so that both systems are there and both are equally good.
So there's one last question, which is asking that the legal mediation process, is it same when two countries are trying to resolve their dispute in international law?
Well, the process is the same. You see, where on the international level, diverging, of course, from this question, we also have the Singapore Convention, where they say that if there's a mediation settlement agreement in one country, and that can be enforced across the signatory countries, that, of course, that's at a different level. But if the question is more between two countries, say members of the United Nations, having a dispute, and committees of mediators are set up to mediate the disputes within the countries, they can use the techniques we talked about. So there's nothing to prevent them from following the structured process which we've discussed yesterday, and they can do along those lines. But the reason why mediation has not really taken off to resolve international disputes, some disputes have been resolved through international mediation, but it's not really taken off, is because of the issue of the credibility of the mediator. For a mediation to be successful, the mediator must enjoy the confidence of both sides that the mediator is neutral, the mediator is credible, and will assure a fair process. International law, international politics, on the other hand, is all about each country putting in giving the priority to their own national interest, whatever is politically expedient for that country. So if you have a third country doing a mediation, or even a committee of people constituted by parties from different nationalities doing a mediation, the mediator's role may be colored by the self-interest of those countries who are doing the mediation. And so that's the reason why other countries do not trust international mediation, or there's no internationally credible institution of mediation where you would say they would put national interests above. United Nations Security Council, we go through the history of it, except for a handful of disputes which were anyway likely to be resolved. Hardly any dispute has been resolved before the United Nations Security Council. For the simple reason that whoever is holding the seat in the UNSC is coming and putting forward, is acting according to their own national interest. So that's the reason why the structure can be followed, the principle remains the same, but I don't really see international mediation being a very effective force unless and until we rise above national politics. We have the ICJ, which has to some extent got credibility, but that is because they're basing their decisions on the evolving international law. So there's a standard. But in mediation, there is no system of accreditation or a basic standard being laid down. That model just doesn't apply. And so we don't really have a body of that kind.
Thank you so much, sir. I think we'll be ending the Q&A session over here. At the outset, I'd like to thank you, sir, for such an informative session, the 2-day workshop that you've conducted with us. All the attendees may now fill a Google form for the attendance as well as feedback. The link for the same has been provided in the chat box. Filling of the Google form is essential for receiving of the certificates of participation. Now, I'd like to invite Dr. Vanna Singh, Assistant Professor at USLS and Faculty Coordinator for today's event, to extend our gratitude and deliver a vote of thanks.
Thank you, Ishita. Before extending the vote of thanks, I just wanted to see the last question. Mohit has asked whether diplomats can be called mediator. So I didn't wanted to miss this question. So, sir, Dr. Aman, if you would like to answer, means.
Well, to start with, anybody can be a mediator. You, as a law student, if you acquire the skills, you get trained in mediation, you can put up a board outside your home and say you're a mediator, and you can help resolve neighborhood conflicts, and you can charge heavily for it also. So anybody can be a mediator, regardless of the profession. What is important is not whether you're a diplomat or a law student or a lawyer or an engineer. What is important is, do you have the skills to do mediation? And so if there's a diplomat who acquires the skills and is actually then mediating on a particular conflict, then there's no reason why that person can't mediate. In fact, what we do is we do suggest that instead of, if you have a problem with a company, they have the dispute resolution, they have a nodal officer and a senior officer. Most companies now are thinking of having, they should be having, in my view at least, a panel of independent mediators who would help resolve the conflict between the customer and that particular company, so that matters don't go into litigation. So the short answer is, whoever has the skills can be a mediator.
Thank you very much. And one more thing I just wanted to add, means he is acting in which capacity? Certainly he cannot be mediated if he is acting in as a capacity of diplomat, because one cannot be neutral when I'm acting on behalf of my country.
No, I would imagine it should be where a diplomat is trying to sort out the problems between two countries, etc. Maybe that's the context in which the question is. If a diplomat is doing diplomacy, his own diplomacy to protect the interests of his own country, then mediation doesn't come in. It is only if he is because of virtue of being a diplomat, enjoys a particular kind of a good office and the goodwill amongst the different nations or countries. And he's using his the goodwill he has to help negotiate to other disputing parties, assisting them to settle their disputes. And he has the mediation skills. He can be a mediator, but that actually also leads me to another point. A good lawyer need not be a good mediator, or vice versa. A good judge is definitely not a good mediator, because a judge comes with a trapping of authority, and the very authority of a judge takes away from that person being able to take a subordinate role in helping a party decide. So we have had in this country judges acting as mediators, which according to me is a terrible idea, because they would actually never be, I mean, they can probably be helpful in lok adalats, but they would not actually be effective mediators unless they get rid of that trapping of authority they have.
Hello, am I audible properly, Ishita?
Yes, ma'am.
Yes, ma'am.
Sorry, due to some connectivity issue and due to that interesting question, we extended program for 2-3 more minutes. So on behalf of ADRCL USLLS, we really extend our heartful thanks to Dr. Aman for accepting our invitation. And in last 2 days, we have seen he has explained each and every minute detail about mediation, that what are the essential skills for mediation, what are the advantages and disadvantages of online mediation. But certainly I would like to say on behalf of all the participants what all of us can make out from the messages in chat box, that it's not sufficient. Our appetite is not filled yet, and we are looking for more session and more interaction with you, sir. So certainly means maybe within 6 months we all are very optimistic, and we all are expecting that we will meet physically in USLLS campus with all the participants and with all the students, so that we can have a physical session with mediation. Because I remember, sir, Dr. Aman, he is having very interesting way of explaining mediation by way of some exercises also. So on behalf of ADRCL and on behalf of USLLS, I'm extending my advance invitation for that also, Dr. Aman. Thanks a lot for giving us your valuable time for 2 days. And apart from it, I would like to extend my thanks to my faculty coordinator, Dr. Zubair Ahmed Khan, who is taking interest in each and every event, and we are trying to organize many more programs from ADRCL. I would like to convey my thanks to Dean USLLS and the student coordinator, who all are working from more than a week in organizing the event and taking care of all the technical thing. Vaibhav, Akshita, Ishita, Tisha, they really worked hard for even in pandemic time and taking care of all the things. So thanks to all dear student, dear coordinator for extending your help to ADR Center. And last but not the least, I would like to thank all the participants because of their overwhelming response. Though today is holiday, but all of them, they have participated. Yesterday also we had very good response. Today also all of them they were with us. And thank you very much once again, Dr. Aman, for accepting our invitation. Thanks a lot. And last, please fill the form so that you will get the certificate in a day or two, since we are having large number of participants. So Vaibhav or Ishita, any one of you like to say? By within a week, I think all of you will receive your certificate.
Yes, ma'am. Within a day or two, or even by today, they will receive the certificates.
Since we are having large number of participants,
Yes,
so that's why it will take some time. So I'm
Yes,
giving some extra time, like within a week, certainly
Yes,
you can the
Sure.
certificate so that
Sure,
our
ma'am, sure.
students can enjoy one day break, right? So within
Sure,
a
ma'am.
week, all of you will receive the certificate, right, Jubair? Anything else?
Yes, ma'am. Yes, ma'am. Okay, thank you. Thank you so much, all of the participants, for participating in the event. I think, Vaibhav, you can sign out, and you can stop the YouTube live streaming live also.